our two speakers, Mr. Anil Lalwani from DL Law Corporation and Mr. Victor Teo from the SME Center at ASME. We shall begin with Mr. Anil Lalwani from DL Law Corporation to start on his first part of re-employment of older employees. Over to you, Mr. Anil.
Thank you so much. A very good afternoon to everyone and for your patience. I hope everyone is having a fairly great day. I can see some nice words already being put up. And let me just start off perhaps by asking, why are we talking about re-employment? What is the big deal about talking about re-employment? And I'll tell you the answer, and I speak from an SME perspective. The real answer to that question is really, as an SME, you want to avoid a dispute with the Employment Claims Tribunal. That is the essence of it. In other words, we don't want any of our employees to suddenly say one day, you've been unfair to me, and I'm going to take this up with the Labour Minister or the Commissioner of Labour and put my point across. No, the ultimate purpose here, ladies and gentlemen, is really to prevent us from ending up at the dispute. So then the next question I ask, and you must be asking me, so tell me, why is it important that I must go through this background? And I have three answers for this. First, we must know what we have done and progressed all of these years. Second, we need to understand what to expect in the future. And three, it's a theme that I am going to share with you very early. And that is, ladies and gentlemen, if you haven't already realized, we have an aging population, and that is going to hit us in a matter of years. So some background is perhaps necessary at this point of time to understand the context. And let me start straight away on this point. When the Act was first introduced in 1993, it was actually only known as the Retirement Act. 1993, it only was known as the Retirement Act. And do you know what was the number of years that was considered retirement at that time? Already considered too long for many people. It was only considered at that time as 60 years. So you work till 60, I have a retirement and I can walk away. And let me tell you, from 1993, and this is quite important, there was already a position that no employer shall dismiss on the grounds of age any employee who was 60 years of age or at that particular time. So this was, it was like a particular section that protected older employees. And you will be pleased to know it still remains. And it's going to be an interesting question later when I ask you why this is relevant to us. So the way it was in 1993 onwards was also very simple. It was just basically making representations to the employer. There was no fixed system. Obviously, by 1999, there were quite a few things that needed to be taken into consideration. In the revised edition by 1999, we had a section that spoke about employee wages being reduced. So we were talking about retired employees and their wages being reduced. So when you start looking at that point, you ask yourself, oh, you mean at that time I could already reduce the salaries of the senior workers? Yes, you could. And there was a clause, quite interestingly, that said that I couldn't reduce it by more than 10%. Why is this relevant? Later, when we talk about it in part 2 of my talk, when we discuss what the wages are, you will realize that that has actually shifted a little bit. So this was already anticipated that senior workers were not expected to be earning the exact salary when they left. It was understood that there would be a reduction. But at that time, in 1999, in that government, they had already considered that, oh, you can't reduce it by too much, you reduce it by 10%. There are lots of factors that have changed. Salaries have actually gone up. At that time, it was probably lower. So if it was too much of a reduction, the person will walk home with nothing. But those are considerations for all of us to discuss in better detail. So what happens by the year 2000? By the year 2000, the key point is that the employer wanted to reduce, he had to give notice. So these are also common themes. If you're not already familiar with re-employment and retirement, by this particular time, I'm still looking at it as the Retirement Act. But if you want to give someone, this person to go away, I need you to give you notice. Fairly understandable. We then move into 2012. When we move into 2012, that's the first time we start talking about the Retirement Act being recognized as the Retirement and Re-employment Act. Now, in this is the place where you start seeing these concepts, okay? There's a wealth of knowledge on retirement and re-employment. What is really our task? Our task today is for you to be able to walk away with some key points in your head, knowing almost like a structure, these are the things I need to check off. And therefore, I know that when I'm dealing with an employee who is a senior person, these are the things that are in my mind. There will never be a possibility that I'm able to cover all of it entirely, but certainly the key points are there. And the key points have got a lot of information as well for you to take away. Now, when you start looking at 2012 onwards, you will see concepts like the employment assistance payment. What is that? I'll share later. Tripartite guidelines, because there is a tripartite alliance that provides for unions between various interest groups to include the interests of employees as well. You start looking at the Commissioner for Labour and no longer the Minister, so that administratively the work can be done. So if you start looking in those concepts, you start asking yourself, oh, that means actually from a very early age, Singapore was already thinking about retirement. And then there's also retirement and re-employment. And also that if I couldn't have re-employment, there was some employment assistance payment. I'll give you details not too long away from here. Now, another thing that happened was in the earlier time, I only had to give you 1 month notice. And then they changed it to about 6 months notice for an employee to be able to give notice that he was aggrieved. And then it went back to 1 month. And again, this is something that is necessary for us to understand what is it that the government is trying to achieve now moving forward. So ultimately, when we moved from 2012 to where we are now in 2020, the one thing that happened was a change in the number. We now have from 60 years to 62 years. And that 62 years meant that we were working longer hours, and there was also a minimum retirement and a maximum retirement. In the 2017 version, we introduced the Employment Claims Tribunal. Now, this is something very interesting, and I shared a small clip with you. What happened was I was actually had just returned from England not too long ago, and I thought that the Employment Tribunal was very important because employee rights were not taken care. And how they were not taken care of was because there was no platform for an employee to go and make a complaint. If he wanted to make a complaint, he had to go to court, he had to go and file a claim, or he had to go and complain to the minister. It didn't work. So they introduced this Employment Tribunal in the hope that there would be lesser disputes between employers and employees. I think it has got good points and bad points because ultimately there's still no presence of lawyers, and sometimes employees are really helpless. They don't know what to do, especially those who don't speak the language very clearly, especially when everything is done in English. But if I can share this moment with why this is necessary, it allowed another concept to be coming through. And this concept that I'm talking about is the talk about conciliation, where mediation then became an element before any action was taken. It is generally the thought process of the courts that we will use mediation as a cycle to help employers and employees resolve their matters. You are going to ask me now, all right, Mr. Anil, you've told me something about the background. I still don't understand the essence. I'll tell you now the essence of this background. What has happened now in terms of moving from 2017 all the way till 2022 is that a person who actually dismisses an employer of a certain age runs the risk of having certain penal action against him, a fine and imprisonment possible. Because when you dismiss someone on discrimination of age, this has been a tenet from 1993 that is carried all the way through, and it remains in a statute. That's one. Two, second theme that's very important is the introduction of mediation so that parties don't have a lot of disputes. And I will show you statistically in a short while how that has happened. Three, recognizing that it's not only about retirement, it's also about re-employment of that particular person. And how do I go about making sure that re-employment is available to a person who has now realized he's reached his retirement age? Okay, now the third, or rather the fourth concept is it introduced eligibility criteria. That's a subset. And what are these two eligibility criteria that we are talking about ultimately? We're really talking about satisfactory work performance and what that means, and being medically fit to continue working. These two concepts right, are a little vague because if you didn't understand how to apply them and you gave the simple, plain reading of it, you will come to the wrong conclusion. Dear SME friends, I tell you why you would come to the wrong conclusion, because you would assume in your favor that that is correct. There are some guidelines. I will share that with you. I now move you to the next point, right? And that is really my next slide, of none other than Marilyn? None other than our PM telling you exactly what is the status right off now. So, ladies and gentlemen, when somebody tells me in 1993 I would retire at 60, I then worry about retiring at 60. Then you tell me I have to work till 62. Then you tell me I have to work till 65. And this only keeps going up. Here, the fact is, if you take the next point on the number of cases that we have, Madeline. I have, from a statistics that we have found out, the manpower minister handles 80 cases or has handled 80 cases from 2016 till 2021. What does that mean? It means that in the 5 years, right, we've had about 15 to 20 cases in which we have had to deal with unreasonable denial of re-employment, disagreement over the terms. I emphasize here the disagreement over the terms of re-employment and disagreement over the amount. Usually that's where the problem is, because someone says I should be paid more, not less, and everything else. I, of course, share in greater detail later while I finish this introduction in a short while with the thought-provoking video for you. Now, you would realize from my notes as well, 90% of this was settled by, no surprise, amicably resolved. And 10% of that actually went up, got escalated to the manpower. So they've actually been doing a very good job so far, of making sure that matters didn't go beyond where they were and they stopped over there for all the employees to be happy and walk away. I'm sure it's a compromise, but at the end of the day, the compromise means that employers, SMEs, are not boggled with problems where they have to go to the courts to solve these problems and try and talk their employers out and discuss. I have a theory there. I think it's very necessary, and we will get to that particular portion. Now, what I want to share with you next is the statistics of what we have. Okay, It's not something that is new. Nearly 1 in 5 citizens is going to be 65 or older, right? And while you can read this statistic quite clearly, what you will see is that there is a spike in terms of the number of years. That's obviously something you may have come across. And more importantly, by 2030, 1 in 4 citizens, 23.8%, will be age 65 and above. Let me give you a perspective in terms of numbers. Now, I looked at this from some statistics as well that I found. In the year 2000, that means in 2000, there were about 200,000 seniors above 65. 200,000, manageable. In 2020, let's just say 2018 to 2020, my statistics moved from 200,000 to 400,000, almost very similar to what statistics I've shown you here. In 2030, 2040, do you believe what the number is going to be? If I told you that there are now going to be 900,000 seniors above 65 expected, and of that population, a very small population would be the working group, 2.1 million people, according to the paper that I had looked at. Now, what does that mean? The plan is the government wants seniors to age meaningfully. And this is where we are. Discharge his job, and that's what it maintains. And that discharge here means a level of performance in the discharging of his duties as he normally would do. No special magic here, just a simple basic point. Now, the employers are expected to take into account 2 to 3 years of performance. So I'll give you a scenario, and this is something that I will share with you. If I started work a long time ago, my performance was very high. In the last 2 years, my performance was average, and my last year, my performance was rubbish. I would have to consider not what was happening at the last perspective, but for the last 2 to 3 years. And because if I found that he was minimally able to perform this task, I should therefore be satisfied that his work performance was there. Now, if you move on to the next slide, medically fit to continue working is a bit more challenging. I do not need to send an employee for a medical checkup. Okay, we're talking about the re-employment, the retirement age here of a person. And at that point of time, 63 years old, the re-employed employees are presumed to be medically fit to continue working. And I'll tell you this point, when we say that, all it simply means is that in law, the employer is to prove on a balance of probability, that means if I weigh it like a measure, as to whether I can show he's medically unfit. Otherwise, I must assume he's fine. Okay? I don't need to send him to a medical checkup. And the clause that caveats this is, of course, if I'm able to show that he's got signs of being medically unfit. For example, a person who comes in crutches, unable to climb stairs. A person who is unable to work many hours because of his illness, because of MCs. It would still be on the employer to prove this particular point. It is a little tricky because when you have this issue going on, this is exactly what happened in Parliament recently, where a member of Parliament, actually a member of Parliament mentioned that if I were to hire older workers, my productivity be affected because they're mostly on MC, or they're not well, or they're not doing too well. Which is why it's very important to understand why these minimum standards are there. I don't have to send someone for checkup. And if I do so, and I do so on a case-by-case basis, it's not just sending one person. It is sending a batch of people for the same job. Because then it would not be fair, as Victor had explained earlier, that a lot of the policies have to be reasonable and it has to seem and look to be fair. This is very critical, right? Now, if I take you to the next point, which is what it matters most at the end of the day. Now, Victor's position from his talk has always been, how do we retain staff generally? It also includes our employed retired staff, the retired age that we have to consider when someone reaches that particular age. But if I'm going to be talking to a senior man, an older person, I have these responsibilities according to tripartite guidelines. I have to identify the eligible employer. Who is he? He's basically my Singapore citizen or my PR. You've got that in your head, right? Clearly, that's clearly very important. I then have to have discussions with him 6 months before employee turns 63, right? Many people just remember at the last minute, oh, no, I have to start talking to the person. In fact, a few times in a few companies that I've advised, they've actually gone past their age and then suddenly having to go. These are problems because they can't complain. 3, you must offer re-employment at least 3 months before retirement. And that retirement age is considered as the age in which the person turns on his birthday. And the employer is expected to follow the tripartite guidelines. This is not something I can carve out. In fact, in contract, even if I want to write in there to say that the Retirement and Re-employment Act doesn't apply, I would be in complete breach of that particular section because there's a specific section in the Act that says you cannot contract out my Retirement and Re-employment Act. So this makes it a little bit challenging for any employer who has not considered a policy for it. Lastly, the good point is that we all understand employers get old, employees get old, and there must be some open-mindedness about change in their job design, change in their job scope, and to some extent, the description of their work may also change completely. And I'll share and explain a case study with you shortly. If we talk about pay, we would need this particular person to make that shift that it may be lower. And this is something that's anticipated a long time. So if you are worried as employers as to whether employees will not understand that there'll be a shift in the pay, you do not have to worry. This is something that has actually worked out for a very long time. Now, let me move on and tell you about some good practices that the tripartite guidelines expect employers to adopt. We're talking about planning and preparing employees for re-employment. We're talking about the re-employment contract, recognizing the contributions of the re-employed employees, and then assisting those employees who cannot be re-employed. This generally is the framework. You will find this information fairly straightforward. But what does it mean? You need to think about career planning and training with forward-thinking mindset. This affects, I speak from a perspective of a contract, Victor speaks from a perspective of a HR director, and therefore we may have different thought processes, but ultimately the contract must reflect the intentions of the party. So when he talks about performance of appraisals and the discussion to start early, this is completely in line with making sure that we do not contravene the Act. Potential training and support for senior employees. Ladies and gentlemen, this is now fundamentally something that SkillsFutures and all the organizations are working towards to try and ensure that everybody is trained. It's critical. If you don't allow your persons to train or retrain them, they cannot fit into the new position. In fact, recently I was in a court hearing, and one of the questions the judges had asked before he could consider was whether this particular staff was given an opportunity to train before they could take on this particular new role. And if there was no training, how was the person going to take on? This is a particular issue that I think everyone recognizes. And as SMEs, we need to recognize that there's no point telling them I can re-employ you, but you don't provide the necessary training for them. Something that I think Victor will take up later. And of course, flexibility of the job arrangement is something that I would have to ask the employee to be open-minded about it. Now, if I take you to the next slide on good practices, we're dealing with at least 3 months before retirement, which is important. We're dealing with employees who continue to be employed beyond 63. So without formal recontract, if you hire somebody, and ladies and gentlemen, this is very important. If you hire somebody or you continue to engage the person after the age of 63, let me tell you that the terms and conditions will be deemed as the ones that you had employed before. Simple example, I have a contract that says you're going to pay me $6,500 a month, and the contracts are all of the terms and conditions. I've hit my 63rd birthday, my HR is sleeping, they didn't tell me anything, they didn't explain to me anything. Fine. You can't come to me, employer, and tell me now, hey, sorry, I must cut your pay now, or I must change your medical terms, or I must change some of your holiday leave, or I must do something with your job. Because if you do not have a contract ready for them, a re-contract agreement, previous terms will apply. Okay? What does that mean for an SME? It just means that you actually cannot renegotiate until you take the pen and paper and you renegotiate the contract. And this is critical. Okay? The next slide, please. Okay, so if I could summarize this in terms of what's necessary, we have good practices that employees should adopt. A lot of information is heard about that. We should give employees ample time to provide adequate training. And the duration of the re-employment is explained. But what is the term is it that we must give them? As you will see in my slide, it talks about guidelines of 5-year re-employment contracts. You know, the first time when I read this, I smacked my head against my head because I told myself, I can't even give myself 5 years. How can I give a staff 5 years? So fortunately, there's a term contract as well of 1 year, which is renewable up to the age of 68. That will change until 70, as long as I meet the 2 criteria, satisfactory assessment and medically fit. Now, ladies and gentlemen, as an SME supporter, this is the only 2 places I'm able to go to my employee and tell him, I'm sorry, you don't meet the satisfactory assessment or that you're not medically fit. Now, if you've not had your communications with your employee, you are going to face the consequence. What is the consequence you're going to face? You're going to face the consequence of an employee going and making a complaint because he says it's unfair. You haven't communicated with me. Victor spoke about this. I think it's very important that we take heed of what is stated in relation to communication. In fact, in my very early years of practice, there were many companies that didn't even have a grievance procedure, a grievance handling procedure. There was no policy. Basically, if I wanted to tell you something that was wrong, I didn't know what to do. Maybe I came to you one day by the side of the coffee and says, hey, your work is very rubbish. Really, I don't want you to be doing your work anymore. In fact, I think you should pack up and go. As opposed to when there was some grievance that was raised, either way, there was a procedure in place, a policy paper that organizations must have, companies must have, SMEs must have, because we don't have so many workers around where we can say, you work, you don't work, you can do so. I don't. These are the only resources I have. Right? So just to refresh your memory on this, there are 2 parts of this. There's a guideline, which has got 5 years re-employment if we can manage, or a year-on-year assessment that we would do. Now, I now come to this particular aspect of what is typically put in the re-employment contract. It's generally all the normal terms and conditions, but I could deal with 3 things in there: wages, medical, and benefits. These are the 3 things that allow me to or allow an employer to go and adjust. Right? I can focus on the employee's needs. So, for example, I may need to help the employee ensure that the person has got certain flexible arrangement. So, the theme over here is for especially the workers who are of the lower range. I would have employees to focus on impact, on what impact they would have if their salary was low. And of course, I'm moving away from seniority based to a job based. At this point in time, let me share with you in the time that I have an example of a case that was recently presented to me. And I'll summarize very quickly. The gentleman is basically a crane driver, and he only knows how to do a crane drive. He's been working in the company for a very long time. Came to the time of his retirement, we had a problem. Because when you are a crane driver, you have to go up all the way to a certain height. You actually eat, sleep, you sometimes do your business also there before you come down, because you can't go up and come down very often. Many meters are up in the air. So what happens? Rain or shine, you have to be there. And it's taxing on the body. And therefore, this particular person only knew how to drive cranes. So he was working in the construction industry. He came down to HR and nobody mentioned anything. This is one of the companies we realized, oh no, we haven't spoken about retirement and re-employment to him. And at this point in time, we came to him and we told him, we've got no more job for crane, as a crane driver. What would you like to do? So he scratches his head and he says, if I cannot drive plane, I can't do anything else, right? So HR then had to sit down very carefully and think about what he could do. And first thought, oh, it's okay, let's leave him, let him go. What would have happened? They would have activated my Retirement and Re-employment Act, because he would have then complained that you didn't give me an opportunity to be re-employed, or you pay me employment assistance payment at EAP. So what happened was the company decided to rehash his job. They told him, look, what we need you to do is drive, because you can drive. Drive in the morning and drive in the evening, and you pick up workers. He was really upset. He said, I'm not a driver. I'm a crane driver. I earn a lot more. After a lot of communication, a lot of discussion, that was a re-employment given to him. You know what is the good thing we have with the Re-employment Act? That when you give somebody a re-employment and he doesn't accept it, it doesn't require you to make any payment for EAP. It doesn't require you to do that. All it requires for you to do is to have given the person a re-employment. Of course, another way is to transfer the employee, but that's even more challenging to some extent, because you have to transfer the same skill set, same worker, and when the person earns less, you still have to cover him with AEP. Now, let me get to this topic about how much is payable. Okay. Do you remember when I started at the beginning, there was no reduction of 10%? Okay. So for wages, what is considered to be a fair wage to pay to somebody who has been working at maybe 6,500? I'll give you an example over here. I've got $6,500, but the market pays this particular person between 4,000 and 4,500. What the tripartite guidelines are telling me now is not about reducing it by 10% anymore, which is what the original salary was, but by considering a midpoint. So if I am earning 6,500 previously, but a person who's of my same skill set, although much younger, is earning 4,000 to 4,500, then I must ask myself whether I can consider the midpoint of these two amounts or the amount that is available. Now, that is very challenging for someone, right, who was earning a certain amount of money and now doesn't have this amount anymore, right? Because think about it. How in the world am I going to go on if I have certain debts and expenses as I keep getting older, or I have certain commitments? That's going to be, but at the same time, communication with the employee is very important. He needs to understand that his salary is going to be reduced, and then have a buy-in from him, and then continue and ensure you keep your end of the bargain on a yearly basis. Of course, when the year comes to an end, the assessment starts again. Is he medically fit? Is he satisfactory in his job? That will be your test. Okay. Now, of course, there are other benefits that can be managed, and that is offering part-time. And given challenge, when you have an older person, it's very difficult for them to manage and be in the senior management position, as you saw in the video, because being in the senior position meant that a junior cannot come in as for leadership. So you may want to consider subsidiary. I ask myself, smack myself ahead again, how can I put somebody in a subsidiary position when I don't even have a subsidiary? I run a few companies. And if I switch them from different companies, then that's the transfer aspect of it, right? So I think at the end of the day, the government is, of course, also trying to encourage employers to hire beyond the age of 68 or 70 to come, by way of an internal retirement and re-employment age. So this mindset must mean that, in short, we've come to a few challenges where we have to accept an older age. We have to accept that our recontract agreement is done. We have to accept that there's a policy perhaps in grievance procedure so that I can take care of the word satisfactory. And if I'm having anyone who is unwell, medically unfit, I think the right thing to do is assume that he's able to work. And if there's any evidence to show otherwise, then do the necessary to check, because these are your only two criteria to ensure whether this person continues to work with me. Having said that, it is employer's responsibility. It's employer's responsibility to hire the person and consider an inclusive arrangement. Okay. Okay, now I am on my last slide. So thank you for your patience on this. And what I want to share with you is actually in relation to two things. An employee who's eligible to, of course, be transferred, that would be a good way to transfer the person. If he's not, I'll have to pay him a one-off employment assistance payment in that respect. Now, if I do that, let me just share with you the information. This information is available. I only offer the person, my senior man or senior lady, a last resort of compensation if I cannot find him another job and I find I cannot put him in my place. And the thought process is a one-time payment of 3.5 months. And there's a minimum of maximum salary of $6,250 to $14,750 being the payment, which means that every employer will have to think about, if I'm letting go of senior staff, I'll have to prepare this amount, keep it in my budget, because this person may not be able to work and will ask for it. What is the purpose of sharing this slide and this topic with you? We want to avoid disputes with employees. An employee will have 1 month after the time that he's let go to go and complain to our employment tribunal and to say that he has had these problems because he was not offered re-employment, it was unreasonable terms and conditions, and there was EAP was not sufficient. Standard 3 things that will come forward before anyone else, right? On that note, I have some concluding comments, if I may share with you. And my concluding comments are as follows. I cannot get away from the fact that we have an aging workforce and we have to take it in all our industries, no matter how many people they think that they're going to bring over. I am going to see challenges that the same workforce has to be retrained with new job scope. And that is the purpose of why we have this act coming in very actively, and the minister even talking about it. There must be a mindset change of the employers and the employees, because this is not just one battle. Communication, this is no longer the get out, ship out, but okay, how do I ensure that I can use your skill set? It will affect wages, but you need to address this very carefully and sensitively. The final point is perhaps in relation to government initiatives that Victor speaks about with regards to all employers, not only re-employment. And I saw that there was a senior worker early adopter grant, but I'm not sure whether how many people actually want to get onto grants and want to manage your current workforce, right? On that note, I am 5 minutes past what I should have spoken of or taken, and I thank everyone for your patience and for listening to me when I present these points to you. If you have any questions, please feel free to reach out to me. And